Thank you. Nice to be back.
With wife and your 2 children and nanny, this is going to be hopefully take a deep breath, relax before you go back into the real world.
Into the storm.
What is the storm now? What's new since last year?
Well, the latest storm is that we're appealing the closing order of the co-investigative judges in the Doik case. It's not a particular situation that I wanted to be in, but I think it's ultimately I think it'll be better for the court as a whole.
Well, back for the purposes of the tape and education. What's going on?
Well, since we last spoke, I was starting to think. At the time, I think we had one accused in custody, which was Doik, which was was the administrator of a particularly notorious detention center, S21, during the Khmer Rouge period. Since then, afterwards, 4 more accused were arrested and detained and remain in custody since 2007, since the 2006. 2007. Here we go. 2007. And what happened after that is that our initial submission, which in this system, in the court system, is the document by which the co-prosecutors request the co-investigative judges to investigate a particular set of facts and individuals and to determine if they constitute crimes within our jurisdiction. Well, that initial submission, which named the 5 individuals being involved together, the co-investigative judges decided to separate his cases, to put Doik and the events of S21 alone as a standalone case and move forward with that one. And Doik and the other 4 remain charged in, let's say, the more national aspect, the more national case. Well, the Doik case, the S21 case, has moved forward. So that in May of this year, 2008, the judges determined that investigations were completed and they had all the facts that they needed. They sent it back to us for our final submission. A final submission is basically the summation of the co-prosecutors as to what we say is the relevant evidence in the case file that is constituted by what we sent over initially in 2007 and what the co-investigative judges then added to it during the investigation. We, in our final submission, advised the co-investigative judges of what we think is the relevant evidence in that case file, what that evidence amounts to in terms of crimes, and which crimes Doik should stand for. We forward that back to the co-investigative judges on the 18th of July 2008, sorry. So a year to the day, on the day, from the time that we had sent our initial submission. After that, the co-investigative judges issued on August the 6th, I believe, I'm not sure, their closing order. Their closing order is the co-investigative judge's opinion on what exactly the relevant evidence is and which charges Doik should stand for. And they forward that to the trial chamber. It's basically it's almost like an indictment, basically. Well, that closing order, despite our requests, did not include national crimes. It included only crimes against humanity, murder, imprisonment, torture, persecution, and war crimes. Again, murder and torture. It did not include national crimes, and it did not include any notion of co-perpetration, which we believe these cases always amount, or at least those who are most responsible for them, are liable, among other theory, by co-perpetration. That's how these crimes are committed. It's a bunch of people agreeing for these things to happen.
What's the conspiracy theory?
It's a different theory. It's a different modes of liability. Conspiracy is planning together, right? Agreeing together, but not necessarily doing anything. And you're agreeing for a specific act. Co-perpetration is part of that. It's agreement. It's an agreement to commit a crime. But it can also be an agreement to commit to a course of action that foreseeably leads to the commission of crimes. Right. And you should be liable for those crimes if they were foreseeable. In other words, for example, how it was, if you send a bunch of armed people into a village to forcibly expel people of another group, then it's foreseeable that violence will happen. It's foreseeable that murder will happen, that rape will happen. And you should be liable for that because you allowed it to happen, right? Well, the closing order does not include any notion of co-perpetration. And we think for the Doi case, as well as for the other cases, it's very important. We have the responsibility to prosecute all the cases. So we filed an appeal on the closing order. Now, probably that this appeal will delay the start of the trial, which was expected to start in September, maybe. I think it still can, provided the pretrial chamber is very efficient, can still start this year. And you have to look at the greater picture here. A delay of a month or two, I think, when you take into consideration the issues, I think is, especially since Doik is our youngest, accused, 65, 66 now, and he's in good health. The work of the court is still proceeding. The other case is still getting investigated. Everything is moving ahead. So I think, as I said, taking a holistic approach to this, I think it was for the best. So this is where we're at now. Hopefully this Doik trial will start before the end of the year. Next year, hopefully the co-investigative judges will have finished their investigation in the main case, in the national case. And that will go to trial sometime next year. We're also facing some issues of allegations of corruptions on the court, on the national side of the court, on the administrative side, not on the judicial side. This is not a vote-buying allegation. They are rather allegations of administrative corruption, people having to pay to get and keep their jobs. That's being investigated, it's been investigated, and it's healthy in a way that people have come forward and that things are getting worked on that scope. We'll see how it eventually plays out.
How's the relationship going with is it Chia?
Chia Liang.
Yeah. Yeah, she's your co-prosecutor, and is she finding pressures that are different than your pressures?
Well, I'm sure she does. I'm sure she does. I mean, you know, we always have to remember, us internationals, when this is my fourth tribunal, that when we come in, we also go out. We also go home at one point. They don't. Okay, and they every night they go home to a whole lot of, you know, a different set of circumstances than we do. I'm sure she has different, you know, priorities and certainly different inputs from different players than I do. The relationship is still very good. We're discussing, we're sometimes disagreeing, most of the times agreeing, eventually agreeing. We haven't disagreed on anything yet, or at least nothing substantial. Obviously, one of the issues that's probably going to come to the fore in the next couple of months is additional suspects. Are we going to prosecute more than just 5 people or not? I still believe that the court will and should, because there is evidence and because the law does allow it, and I think because it would be very important for the credibility of the court. But we'll see if the evidence bears that out. Ultimately, that's a decision that Liang and I will have to take together based on that evidence and the law. I think that's probably the next, you know, the next storm as well.
You're trying them under Cambodia law. What's the challenge there?
We are indeed tasked with applying national law. Because of the recent history of Cambodia, that national law is far from clear. There's been all kinds of upheavals, as you know, and the legislation is very, it's a mixed bag and very unclear. There's no, for example, there's no jurisprudence that we know, like we know of. There's no, you know, there's not a repository of previous decision that you could go to guide you in interpreting dispositions. Those dispositions are not even clear, and sometimes they're contradictory. And you know, that's sometimes we see that a lot in our relationship with our colleagues. We'll say, well, no, the law says this, and they will say, no, the law says that. Or that's not how we do it, because there's a confusion between practice and legal precedent, or legal interpretation. What we did is that we adopted this relatively comprehensive code of internal rules that governs the court. We based that on what was then the draft, which is now the National Code of Criminal Procedure, which is brand new for them, for the nationals as well as us. But we based our internal rules on that and on some international law and procedure to ensure that we have a fair standard in our trials. And what we see is that when we're day to day trying to interpret those internal rules, we come to this, as I said, this dichotomy between us interpreting the text and based on precedents that we've worked on, and the national interpreting the text according to their normal procedures and practice. It makes for interesting discussions, and it makes, it's one of the interesting challenges of these courts is you're making law, right? You're exploring different concepts and creating law. So it's a very interesting working dynamic, let's say.
Nuremberg was criticized because of the application of ex post facto laws to the situation. Are you running into that?
Well, we have a particular some particular circumstances. We have to apply or figure out what the law was in 1975-79, because that's our jurisdictional time frame, and we have to apply that law. And indeed, we may we had one challenge, one accused, saying that he had been already tried, he had benefited from a pardon. And in any event, because he had been tried, although in absentia, he should not be tried again for res judicata. But one of the issues that we're going to face probably is the definition of some of our crimes, like crimes against humanity at the time. One of the issues that comes to mind, it did, at the time, 1975-79, did crimes against humanity necessitate a nexus with an armed conflict or not? Now the law is pretty clear it doesn't. It can happen independently. But historically, notionally, crimes against humanity evolved from crimes committed during an armed conflict, and there was a necessity for a nexus, or there could have been at one time. There's sort of issues. So, yeah, that's going to be interesting.
What kind of time constraints are you and Chia under?
Well, everybody wants to get on with it as quickly as possible, right? It's been 30 years. People have waited 30 years for answers, for some closure, for some justice. Our accuseds are getting older, and they're, aside from Doik, who's 66, the others are all in their 70s or 80s. Our witnesses, our survivors are getting older. Our evidence is getting old. The donors have said from the beginning that this was going to be a short time exercise, that they were not interested in funding a long-running project.
Yeah.
And that's a legitimate position. We have presented, we were initially supposed to last 3 years, 2006 to 2009. We had to revise that, obviously. Those expectations were, I think, completely unrealistic because of the enormity of the task and the resources that we were given to do it. Now we've presented a supplementary budget, basically a fundraising document, where we ask to be able to be funded until the first quarter of 2011. I think that's still possible, that will allow us, if the funds are there, to deliver a reasonable measure of justice, a reasonable exercise. It has to be credible, right? It has to have the right people on trial for the right charges and done the right way, so that the Cambodian people can see where all that money went, and it hopefully provides them with some of the answers they're looking for.
And some of the answers is why that occurred. I mean, it sounds like it's still not clear.
No, because we haven't had a public audience. And because of the nature of the civil system, the continental civil system, the investigation is secret, is confidential, and that's one of the criticisms we've faced, is that people don't know what we've been doing, or at least don't know that much about what we've been doing.
Right.
That's the nature of the system. These people are presumed innocent. They're only charged or under investigation, even though they are detained, based on sufficiency of evidence to lead to believe that they did commit those crimes. However, the results of those investigations, up until now, up until the closing order in Doik, which document is public now. Thankfully, the judges have made it public, which allowed us to make our closing submission public, which is I think, a bit more comprehensive and will allow people to get a better idea what the evidence is. People don't have access to much information. That's what the trial is for, right? Hopefully. As I said, hopefully that trial will start before the end of the year. It's going to be a public trial for the most part, I would think, except for maybe witness protection issues. We adopted in our internal rules a disposition that says that the trial chamber cannot base its decision on any piece of evidence unless that evidence has been either read out in the record or summarized in public. So hopefully anybody who attends, and the public record that will be left behind, will show every piece of evidence that's going to go into the judge's decision. I think that's a very good thing. What we're facing, I think what we have to face right now, what we have to start doing, and what we've done, I think in good part because of the OTP's leadership on this, is that we're now thinking about legacy right away, residual issues rather. We're thinking about how to leave behind what we've done in a way that will help Cambodia understand what happened and move forward maybe. It's one of the issues with all these courts. It's a critical issue with all these courts. Is how do you leave behind all of this, the work product, right, and make it accessible, understandable, usable by people who want to find out more, okay, or want to understand what happened. It's one of the things we've started working on now. We're going to face some particular challenge because of the nature of the court, because it's a national court with its own rules. As I said, the secrecy aspect is one of them. There are also no precedent whatsoever for court records to be available to public. We're going to need money. These things always need money. But I think it's as fundamental as international standard trials that we leave behind this record in an accessible, usable way for Cambodians and anybody who wants. Because otherwise, all they'll have is those public hearings, and that's it. So the record has to be there. And all these courts are now facing this. There's a flurry of activity on how to set that up properly and how to fund it. By the time we close, we should have a precedent, hopefully, maybe, in terms of the ad hoc tribunals. We'll try and learn from that.
Yeah. You're going to sit down today and tomorrow with some of your colleagues. One who's in the news and who is in Colombia, unfortunately got scheduled out here, is Luis. If you had to ask a question of him in his absence, but ask a question if Luis were sitting here now and what's going on with Bashir, what would you ask him?
Well, I don't know what I would ask him. I mean, on a professional level, I'd be interested to know what kind of evidence he's got. Obviously, although obviously not breaching any confidentiality issue. Aside from that, I mean, I'm not going to ask him, are you feeling the pressure, or because obviously, he does, and that's what this is about. These decisions bring those things about. Certainly not going to ask him if he's got any travel plans to Sudan in any time soon. But I mean, I would certainly tell him anyways that I commend him, and I'm quite proud of once again, that the rule of law prevails over everything and anything. I remember when Louise indicted Milosevic, I couldn't have been more proud of her and of this type of work. Ultimately, it's the only guarantee that society can move forward if the rule of law does prevail. So, yeah, it's too bad he's not here.
Well, we can have Fatou, who will be here. We can ask her at this. I'll be most anxious because
sure.
They're in the eye of the storm right now.
Yeah, well, I mean, that's the idea, and there had to be a test. There had to be that sort of thing. I'm sure they have, sufficient credible and solid evidence to go forward with such a move. So I hope I hope it does get to play out the way it should. Obviously, the Security Council may have something to say about it or not. But I think personally, it's important that nothing interferes with the application of the law.
And where it stands now is that there is an application before the court for the arrest warrant.
Mhm.
Isn't that where it's?
I think so. Yes.
Yeah. So that's the next decision-making
Mhm. Yeah.
moment.
Yeah.
Um,
And of course, the Security Council can put a stop to it.
Yeah.
Now, that's also the application of the law, right? It's also in the law. It would be a legal, lawful act of the Security Council. I don't know. I mean, this is really where now legally, I think, well, at least, it's a clear intersection, right, of political priorities and the application of the law. And it's statutorily called for or possible. We'll see.
I got the sense from all of your colleagues that you really don't have an opportunity to sit down among yourselves and just chat, to talk. And they all kind of look forward to this chance, not only to sit on the porch, but maybe have a little more quiet time built into the schedule Tuesday morning where it's just you guys. Is it beneficial? I mean, though we like to think it is, but just to be able to take a break from it all, go someplace that's rural like Chautauqua, is that something that is beneficial to you?
I really believe so.
Yeah.
I mean, it's especially now with a set time where we're just going to chat about whatever we want. It's always useful first to find out, that there's other people with but maybe to clearly enunciate that other people are going through the same things or have the same issues, possibly come up with different solutions to it and exchange on that. It's also useful to be able to talk about and figure out what the next problems are going to be. And that comes through, maybe more through unscripted exchanges like this than other types of conferences or get-together. I think it does. I think it's very useful. It's led to further, to further conversations or more exchanges on some practical things. And I really commend the Institute in allowing that to happen.
Well, we're thrilled to have it happen. I mean, it seems to have it is unscripted,
Mm-hmm.
and an opportunity to chat, and I appreciate that all of the efforts that are made by so many to make it happen. What's the question that should be asked of you that probably hasn't been asked of you in a while about where the Cambodia Tribunal is going? That question you've been waiting for, but nobody's ever even thought to ask you?
I've been asked, I think, all of them. There's quite an active civil society and media life in Phnom Penh. Ultimately, I think the only question that really matters is it worth it? Is it going to contribute to justice for the victims and for the survivors? I still think it can. I still think it will. I certainly might have wished for different ways of going about it in terms of mandate, resources, laws. But I think we've come much farther than a lot of people anticipated. A lot of so-called Cambodian experts thought that we would be at. I think we're always going to face challenges. If it's not this one, it's going to be another one. It's a young court that will never get old. Never will have time to settle down and be tested. It's going to be a constant test. And since it's such an original one, such a different one, all our tests are, not all of them, but A lot of them are new. It's not an easy, certainly not an easy court to work in, but at the same time it provides, I think, from the ones that I know, the ones I worked in, it's certainly the most, provides the most opportunities for learning different things, and in theory at least has the most potential to leave the most important legacy once we do go away. That's an opportunity, I think, that hopefully won't get lost. I think it will matter. I think it does matter. I firmly believe it does matter. And I hope that I still believe that what we will do and what we will leave behind will help and will provide some measure of justice, will provide some of the answers that people are still looking for, and some satisfaction that the right things were done in the right way. It's about all we can hope for.
Thank you. This has been a great update on the wild world of Robert Petit.
Well, yeah, at least Cambodia. The Cambodia aspect of it, the ECCC aspect of it. Yeah, thank you. Like I said, I think this is a great opportunity. I hope it goes on for a long time.
Well, it's our hope also, and there was wonderful reaction last year, and as much, if not more, this year, and it doesn't happen without you guys. I mean, if you decided that, obviously, you could have all the conferences in the world, but what makes us a little bit distinct is you prosecutors here, and hopefully feeling comfortable about being here, and also knowing you have quiet time and you're not just in the public glare.
Yeah, I mean, there's the International Prosecutors Colloquium, which hasn't happened this year. I don't know if it's going to happen or not. But that's a more formalistic, and it's really you have to focus on issues prior, you have to produce papers, and it's really quite a working meeting focused on specific issues. This one is unlike the others, and unlike any other conference. It really allows, like you said, a more free-flowing exchange of ideas and hopefully a more creative outcome.
Well, as last year and more so this year, there's a Nuremberg Trial Connect, because the 3 surviving Nuremberg prosecutors are here, as well as the official photographer of the Nuremberg trial, a guy who wrote and covered it for the Stars and Stripes, so a news reporter will be here, and one of the prison guards of Hermann Goering will be here.
Oh, really?
So it's a kind of a historical gathering, with this being the focal point. But for you folks, you're going to see a bridge back to the 1945-46 International Military Tribunal.
Well, it's helpful to remember to be reminded of where we come from.
Yeah, exactly. Well, that's part of what we're accomplishing this week.
No kidding.
Yeah.
So Whitney's coming as well?
Whitney's coming. He's 96.
Wow, great.
Henry King's 89, and Ben Ferencz is mere 88.
Yeah. Saw them both last fall in Cleveland at Case Western. We had a conference there. Yeah, but I didn't know Whitney was coming too. Wow.
Yeah, and he's struggled a little bit health-wise, and he's wanted to make this a priority, and damn it, he's doing it.
Great, because last year you had said it was the last public appearance. Great.
That's right. He announced that was his valedictory, and we kept pushing and saying, you gotta come back, so he'll be part of a panel.
Wonderful.
Yeah.
Oh, wonderful.
So you'll see him tonight.
Look forward to it.
Thank you.